Next case to come before the court is...
Yes.
State of Ohio versus Patrick Gall. Each side will have 15 minutes to make their arguments. I will leave you track of the time. Again, don't use names of any victims, minors, children. We've read your briefs. We are ready to proceed when you are. 5 minutes again, counsel.
Yes, yes, Your Honor. Giovanna Bremke, again, on behalf of Mr. Gall here this morning. This is my last one, so you're done with me after this. I'm going to largely focus on the speedy trial argument of this. There's 3 assignments of error, but again, the speedy trial is important and probably, according to my research, a matter of first impression, not only for this court, but other courts in the state. So, Mr. Gall was indicted on 6 counts, including murder. There was firearm specifications. He was ultimately sentenced to life in prison with parole eligibility after 28 years. Mr. Gall, throughout the course of the entire case, had consistently held that he was that there was a speedy trial violation that had occurred, and that's it's properly addressed and it's consistently addressed. He never waived his right to a speedy trial, and he was never released from jail. So he was arrested on July 10th. The trial court, the defense attorney had moved to dismiss based on speedy trial grounds October 9th. And again, before the start of the trial, had renewed that motion. The interesting in this case is on November 5th, the jury trial began in that the jury selection had occurred. But the trial, the opening statements in the trial itself, including the testimony, did not begin until November 13th. So from the 5th until the 13th, there was no proceedings in this matter.
Was the jury sworn
The jury was sworn.
before the 15th?
Yes, on the 5th, I believe. That's the first day of the trial, and then there was no proceedings until the 13th.
Well, let me ask you this. Did jeopardy attach when that jury was sworn? I guess what I'm saying is legally, jeopardy attaches. So how can you have jeopardy attaching when the jury's sworn, but the trial doesn't start until testimony is taken for speedy trial purposes?
Right. I understand what you're saying, and I believe that there's...
I'm glad you do. Thank you.
I believe that there is case law that it does attach, and at that point his speedy trial would potentially... it's my argument that the speedy trial had lapsed before that.
Even before
Yes.
Bordeaux began?
Yes.
Okay.
And it would have been October 9th, so well in advance of that, either the November 5th or November 13th. The only tolling event here was that the defense counsel had filed for discovery, and the record is clear that within 1 day, the state had provided that discovery. So it's really not much of a tolling event at all. But the state argues that there was the triple count rule does not apply because Mr. Gall was sitting on a juvenile holder. And again, this is where I believe there's a lack of case law as far as juvenile holders. There's certainly plenty of law, State versus Brown, State versus Martin, that a parole or probation hold would negate that triple count, so you would sit 1 for 1. But a juvenile holder is different, and the best equivalent to that scenario is the Sanchez case, and that's actually a Supreme Court case, Ohio Supreme Court case. And in Sanchez, it wasn't a juvenile holder, but it was an ICE holder, ICE detainer. And the argument there was, well, he's being held on the ICE detainer, so he doesn't, the triple count, he's he's sitting 1-for-1, the triple count doesn't apply. The Supreme Court said no. And in their justification, they list 3 reasons why the ICE detainer is different than a parole or probation holder, and those 3 are also applicable in a juvenile holder. So, one is that the ICE holder is not subject to the International Agreement on Detainers, same as applicable in juvenile holders. The second is that an ICE proceeding, an immigration proceeding, is a civil in nature. The Ohio Supreme Court has also held in re Anderson that juvenile proceedings are civil in nature. So again, 2 out of 2. And the third is that ICE detainers are not themselves subject to speedy trial proceedings. And again, same here, State versus Reed in re Washington, speedy trials limitations do not apply to juveniles. So again, all of those same justifications that the Supreme Court had used for this ICE detainer are the same in a juvenile holder. So that would mean that the 1-for-1, that the triple count applies, and that the state only had 90 days plus this small tolling event to bring my client to trial. Their argument again is that that's not the case because of this juvenile holder. I'm going to again point to the State versus Green case in which stands that the burden shifts from the defense has to make the prima facie case that the defendant is being held past the speedy trial time, and then the burden switches to the state to prove that. In this case, there was some talk about this juvenile holder, and this is on transcript page 6, but they do not present the holder themselves, and they do not present the holder, they do not present any testimony from that, a representative from the holder. It was County Juvenile Court, and my client was actually never even picked up on the holder. It was eventually, he was sentenced in this case, and he was never, they never picked him up on the holder. And they also admit that it's clear, everyone admits that it's a juvenile holder, which again is important because juvenile holders are the same as what the Supreme Court has held as an ICE detainer. It's a civil holder that wouldn't be the equivalent for speedy trial purposes. The second assignment of error is that due process was violated in permitting 2 deputies to stand besides Mr. Gall throughout the trial. Defense counsel raised this argument in which I don't, again, it's a unique argument, and I don't know that it's another matter of first impression, I believe, but essentially that the deputies being there are the equivalent to shackling, or the equivalent, what I believe would be more equivalent, is that it's the equivalent of jail clothes as opposed to street clothes, and there's certainly case law on that. The federal case law, Estelle versus Williams, on the wearing the jail uniform as opposed to street clothes, and the effect that has on the jury. Counsel objected again on page 119 and makes a fairly good record of where the deputies are standing, and the fact that this is an equivalent to a shackling in front of the jury because of the presence of the deputies and where they're positioned in the courtroom. The third assignment of error is that the trial court judge erred in denying a jury instruction for recklessness and negligence, and defense counsel objected to this on page 607 of the transcripts prior to the jury being instructed, and made the argument that those instructions should be included in in the jury instructions, in the trial court, judge denied that. Any questions? I'll reserve the rest of my time.
Good morning, Your Honors. Lindsay Poprocki on behalf of the state of Ohio. The state's response to Gall's speedy trial argument is twofold. The state submits that because Gall was subject to a probation holder and because the time in which to bring him to trial was extended pursuant to RC 2945.72H, at his counsel's request, his right to a speedy trial did not elapse and the trial court properly denied his motion to dismiss. Based on the triple count provision in the speedy trial statute, if the accused is held in jail in lieu of bail, the time within which to bring him to trial is 90 days. However, this triple count provision applies only when the defendant is held in jail solely on the pending charge. It does not apply when a valid holder has been placed on the defendant, detaining him in jail for some other reason. Here, evidence was presented that a holder was placed on Gall, which was acknowledged by his trial counsel on several occasions and served to defeat the triple count provision in the speedy trial statute. The procedural backdrop of this case is important and reflects not only the existence of a holder, but also that the time limit to bring Gall to trial was extended by trial counsel's request when he indicated that he needed additional time to prepare for trial. So I'm going to go over a few of those dates here. On July 10th, 2018, Patrick Gall was arrested. He was placed into the custody of the Lorain County Jail and charged with aggravated murder. On July 12th, 2018, a juvenile probation holder was filed from the Cuyahoga County Sheriff's Office. Gall was indicted on September 14th, 2018, and arraigned on September 24th, 2018. At that time, he asserted that he would not waive his speedy trial rights. His trial counsel also acknowledged at that time that a juvenile holder was in place, and I quote, "The state has at least 270 days to try the defendant."
Counsel, let me ask you that. Obviously, we've heard prior arguments solely on the pending charges is an argument to be made.
Correct.
But there's also that ICE case that talks about not every holder is going to be affected. How do you reconcile?
Correct. The state would submit that this is not a matter of first impression for this court, and that the Sanchez case is an opposite. First, this is not an immigration case, and this is not a juvenile case. In the Sanchez case, the court's holding was based on the rationale that a detainer filed by ICE does not purport to hold a defendant in custody. That makes it different than a probation or parole holder. Rather, an ICE detainer may lead to further custody by federal immigration to allow for an administrative complaint or deportation in the future. And that way, it's unlike a parole or probation holder, and because an ICE detainer does not hold a defendant in concurrent custody.
So if bail was made, then the person could be released under the ICE detainer.
That would be our argument. And also here, as counsel indicated, on October 9th, 2018, a status conference was held with the court. At that time, Gall maintained that it was his 90th day to be brought to trial under his right to a speedy trial. However, and this is important, and contrary to his indication here, no motion to dismiss was made at that time. The state, while acknowledging it was Gall's 90th day in jail, did not concede that it was his 90th day to be brought to trial for speedy trial purposes. Rather, the state presented evidence of the juvenile probation holder and indicated that the best case scenario for a defendant to be brought to trial for the speedy trial time to run would be on November 5th, 2018. Gall's counsel then indicated again, that he was aware of the existence of the holder and that Gall was aware of the holder as well, as it had been provided in discovery. Gall's counsel specifically indicated that based on what he was told at the Lorain Municipal Court at the arraignment, that at all times he believed that that the state had 270 days to try Gall.
The counsel, the trial counsel could be wrong.
Correct.
So it seems like you're almost making a waiver argument in regard to that. And I'm just trying to figure that out.
It could somewhat be a waiver argument. There's Ohio Supreme Court case law that when he finally did make his motion to dismiss, which was at the day of trial, that counsel argued that, again, I'm not sure that I would concede that he made a prima facie case to shift the burden to the state, because he only alleged that there was not a holder when he made his motion to dismiss. He did not allege that he was being held solely on the pending charge, as we've heard argued earlier today. But the state did argue in response that trial counsel had acknowledged the existence of the holder on several different occasions. And if I could go back a little bit, at the pretrial conference held on October 9th, trial counsel also indicated that to be adequately prepared for trial, he simply could not try the case on November 5th. And at that time, the trial court issued an entry where it said that it would extend the speedy trial date beyond November 5th at counsel's request. And the trial would not begin until November 13th.
So that would be the waiver.
Yes. So the state would argue that it established both that the speedy trial limitations had not expired due to the valid holder, and that the time limits were extended when the trial court granted defense counsel additional time to prepare for trial based on his representation that it would be impossible to try the case on November 5th. Again, it is important to note that trial counsel at no time disputed the existence of the probation holder. He acknowledged it on multiple occasions and specifically stated that the state had 270 days to try Gall. I would refer this court to the Ohio Supreme Court case of State v. Brown, where it found the transcripts of the hearing on the motion to dismiss and a pretrial conference with the court provided a sufficient basis to conclude that there was a valid parole holder on the defendant. Because the court noted that Brown's counsel did not dispute the existence of the holder and in fact acknowledged that he was being held on the pending charges and a parole holder. The state submits that the issue is not whether or not the holder was a juvenile holder, but whether Gall would have been released on the felony charges. As to the second assignment of error, the presence of the two deputy sheriffs who Gall claims were seated directly behind him did not erode the presumption of innocence to which he was entitled. While the state recognizes that it is possible that security within the courtroom might, under certain conditions, create an impression that a defendant is dangerous, the U.S. Supreme Court has recognized that reason, principle, and common human experience guard against a presumption that any identifiable security guards in the courtroom is inherently prejudicial. And a review of a claim that such security force or guards in the courtroom would be prejudicial is to be examined on a case-by-case basis. Here, Gall's counsel expressed his concern that the presence of two deputies in the courtroom was eroding his client's presumption of innocence, because he claimed that two deputies were sitting directly behind his client. And then the court clarified that those deputies were not sitting directly behind Gall, but that a deputy was on one side and then another deputy was clear on the other side of the courtroom. Based on that clarification, Gall has failed to demonstrate that the security measures were in any way extraordinary or actually prejudiced him in any way. Because the presence of security in the courtroom is not inherently prejudicial, he has failed to carry his burden to demonstrate any actual prejudice, and his argument that he was denied a fair trial on this basis is without merit. And lastly, the state would submit that the jury was properly instructed in this matter regarding any definitions on purpose or knowledge, and it was not entitled to an instruction as requested on the inferior mental states of recklessly or negligently. This issue was not properly preserved for the appellate court, as the trial counsel in this matter did not object to the failure to give this instruction at the close of jury instructions. Therefore, the issue would have to be raised on a plain error matter for the appellate purposes, and it was not raised in the brief, and this court should not construct an argument on behalf of Gall. On appeal, if there aren't any further questions, we would ask that convictions be affirmed.
You have your full 5 minutes.
Thank you. There was a question about whether there was a waiver of the speedy trial, and I think that the state represented that it was a waiver made on the day of trial, or in essence a waiver. There's a copy of the motion, or it's actually called a renewed motion to dismiss for speedy trial, made a part of the record, and it was filed the start of the opening statements, November 13th. And specifically in that motion, it says defendant has never waived his right to a speedy trial. So it's clear, defense counsel raises the argument, presents case law regarding speedy trial, certainly established that, that prima facie case that speedy trial had been violated, and at that point, the burden switches over to the state. This isn't a case where it's even questionable whether that initial prima facie case was made. There was a written motion, there was discussions on the record, an oral motion prior to that in October, and then the written motion on November 13th, asking to dismiss, specifically addressing speedy trial, and mentioning that Mr. Gall had never waived his right to a speedy trial. And specifically says the date in which Mr. Gall should be brought to trial was October 11th, is what defense counsel had calculated. Defense counsel wouldn't have waived. I think the argument is that he had agreed that the holder was a holder and the triple count didn't apply. He specifically, again, in writing, in his motion, says that the time to run was October 11th, which would be consistent with a triple count, not 270 days, which was the 1-for-1. Again, this is an interesting issue because of the juvenile holder, the nature of a juvenile proceeding being a civil proceeding, the nature of juvenile proceedings, and it's cited in my brief that, when a juvenile rule 7, that there's certain time limitations on juveniles, that they have to be brought before the court in 72 hours, that there's certain time limitations that are not speedy trial limitations, but again, this is a civil proceeding and identical to the ICE detainer.
Does it matter that it was a juvenile probation violation that he was sitting on?
No, I don't think it, I think that the state is trying to paint this as, well, it's a probation violation is a probation violation. I don't believe so, because it wasn't, had it been maybe sentence time, like a failure to report to a report date for a jail sentence, maybe that would be different. But that's not the case here. The judge hadn't imposed any additional, the juvenile judge hadn't imposed any additional time. And it would be, it's a probation violation, is not a probation violation. This is a juvenile proceeding, it's a civil proceeding, juvenile, it's, the Sanchez case did not stand for, if bail was posted, he would have gotten out today because ICE may or may not have come and got him. It specifically mentions 3 factors, and those 3 factors are identical are to this case. The international agreement on detainers, not juvenile holders are not subject to that. The civil, the proceedings being civil in nature. Juvenile proceedings, Supreme Court has held, they're civil in nature. And the fact that ICE detainers are not subject to speedy trial proceedings, and again, the Supreme Court has held that speedy trial does not apply to juvenile proceedings. So the analysis in the Sanchez case is if that analysis is applied to this case, and that's what the Supreme Court has told us what the analysis is, as far as does a detainer count for the triple count, it doesn't meet the burden. Another interesting thing to consider is whether if a juvenile is given time in a juvenile case at a detention center, whether that can be ran consecutive to adult time, which I don't believe it can be. And that's important because if you're counting 1 for 1, those days in the Lorain County Correctional Facility as an adult are not going to count as your juvenile days in a detention center.
Well, you couldn't get consecutive time on a misdemeanor either, but a holder in a misdemeanor case could still put your 3 days in place, you know what I'm saying?
Yes, and I guess my argument there, my response to that is that juveniles are placed in different facilities, and the nature of a consecutive sentence on a, to say, well, you have to spend 90 days in a juvenile detention center and then 90 days in it as an adult is different than a misdemeanor in which.
Misdemeanors are placed in different facilities, they're jails, not prisons.
Sometimes, yes, but generally have the same nature of, a juvenile proceeding is obviously we know is different because it's civil in nature, it's aimed more towards rehabilitation, whereas an adult proceeding is different. The case law is clear on that, and those.
And with that.
I'm going to wrap up. So again, we would ask that you hold that the speedy trial has run at a triple count, and that the case should be dismissed for violation of speedy trial. Thank you.
All right, thank you both for your presentations today. We will take the matter under advisement, issue our written decision in due course, as we know to both sides, posted on our website and that of the Supreme Court.